welcome to all of you in the room and joining us online. My name is Rachel Piontek, and I'm the Senior Associate Director of the Stigler Center. Today, we are happy to host, again, the second session of our two-day mini course, Can Antitrust Save Democracy? Insights from Europe with Professor Maciej Bernatt, where we will continue to explore the relationship between antitrust law and democracy with a focus on media markets. Before we begin today, please note we are on the record, live streaming, and we will post the event video on our YouTube channel later, as we did yesterday. If you have any questions for Professor Bernatt, we will have time in the last 15 minutes. Please wait for the microphone before speaking. As usual, the views expressed by speakers are their own, not those of the Stigler Center or the University of Chicago. And now please allow me to very briefly reintroduce our speaker today. His full bio can be found on our website. Maciej Bernatt is the chair of the Department of European Economic Law and the Faculty of Management at the University of Warsaw. He is also director of the Center for Antitrust and Regulatory Studies and editor-in-chief of the Yearbook of Antitrust and Regulatory Studies. He teaches EU economic law, international and comparative competition law, as well as a course on business and human rights, among others. And now I will turn it over to Professor Bernatt. Thank you again.
Good afternoon. Thank you, Rachel, for introducing me. I'm very happy to be here again. Thank you to everyone from Stigler Center who is involved in making this course possible. Yesterday we were discussing more general questions concerning democratic backsliding, focusing on Central and Eastern Europe, particularly on Poland and Hungary. And we discussed how these processes that are linked to democratic backsliding, how they are relevant to media markets. The question we addressed was how to define media plurality, and in this context, at the end I posed the question about competition law. What can we achieve through competition law, and whether we can consider other solutions that could help in addressing the challenges that democratic backsliding poses to media markets. So today I want to continue with this, discuss solutions, focusing on the role of competition law, discussing its potential pro-democratic role. Then I will try to discuss certain improvements one could consider for competition law to be better equipped with in addressing the challenges that democratic backsliding poses to media markets. And I will finish my presentation with discussing alternative approach, complementary approach. Let's see how you will see it, and I will focus on the EU Media Freedom Act, the regulation that was recently adopted by the European Union. Just to make sure we are on the same page, I presume you know this, but competition law, very important area of law, and basically if you look across all the countries in the world, most of the countries in the world today have some competition law acts, what you will find there almost always is a prohibition of anti-competitive agreements, prohibition of monopolization or abuse of dominant position. This is the term that is present in the EU. And the third typical element is a merger review system, where basically the transactions that may pose the risks to competition need to be notified to competition authorities. So we are talking about this three group of rules, and you need to understand that traditional approach to antitrust, at least in last 20, 30 years, was really to focus on how competition law can correct markets. So the discussion on the extent to which competition law can help democracy is to an extent new. One could argue that's old, but it's not obvious. When we think about media markets, what is particularly relevant here, you will find the provision from the EU regulation. Particularly relevant is a merger review system. I believe that there you can potentially discuss the role with respect to media markets. And the test in the EU is that concentration which would significantly impede effective competition. So the focus is on effective competition. So the question might be, how can you protect media plurality within such a test? So this is as of introduction. Another point I would like you to have some general knowledge is the question on the relation between regulation and competition law. This is, some people would probably disagree with that, or but theoretically the way of approaching it was always that competition law takes the market as it is, so it is kind of an ex post intervention. We have anti-competitive practice, we intervene through competition law as far as a certain individual practice is concerned, whereas regulation is kind of more of projecting the market, how to change the market condition. And also the intervention is slightly different. It takes ex ante approach. So this is the difference you need to bear in mind when we will be discussing how competition law can interact with media markets and what can we achieve through regulation. The examples include, you can on one hand discuss application of competition law, let's say to dominant telecommunication operators, and on the other hand, a regulation that is supposed to open the markets, telecommunication markets, to a greater competition, for example, by lowering entry barriers. So this is as an introduction. So we are more or less on the same page. So let me discuss right now a potential pro-democratic role of competition law. This is based on my working paper. This is work in progress. I'm also looking for your feedback. So if you think about competition law and democracy, and this is something that I already mentioned, that it's not that thinking about this link is not that obvious. You could argue that through competition law, you may achieve a situation in which market power is subject to control. And so if you think particularly about firms with a very big market powers, by applying competition law, you in a way, you limit potential negative influence of big firms vis-a-vis democracy. And maybe if some of you attended the Stigler conference last week, the discussion was to a big extent about this. So the question, if you particularly think about digital platforms and they have in the US big market power, the question is whether you can apply competition law also to address the threats that are posed to the democracy. And this is, quite this is subject to the debate at the moment. My approach is that I think making such a general claim is possible, but it is not easy. I think it's easier really to focus on certain markets and think more kind of from empirical perspective, where you could argue that such a link exists. And I think that indeed media markets and enforcement of competition law on media markets can be the area where looking for such a link makes sense. The other area, and this is I already discussed this briefly yesterday, if you think about certain changes in the economy that resulted from democratic backsliding, at least to an extent. So the increase of market power of state-owned enterprises, or the increase of market power of firms that have a connection with the government, then potentially, if you think about the enforcement of competition law against such firms, so imagine that there are powerful firms that support illiberal government. If you think about the enforcement against such firms of competition law, this imposes the limits on the use of market power by these firms. So indirectly, at least, this may also enforcement of competition law can be helpful to democracy. And such an approach is, I would say, is in line with the history of US antitrust law and legislative intent this is something we discussed last week, and something that is quite discussed in the US today. In the EU, there is this concept that put forward by ordoliberals, German ordoliberals. They very much, I would say, influenced the construction, the legal ideas behind the EU internal market. And over there, the idea is that, okay, so we have a key is individual economic freedom, right? And we need markets, open markets, to make it possible for this individual market freedoms to really exist and be fulfilled. However, they were considering that there is a need for the state to impose a certain structure of the markets where this individual economic freedoms can really exist. And from this perspective, competition law plays an important role within what could be referred to as an economic constitution. It protects markets from the domination by firms who could use their market power in such a way to undermine this individual economic freedom. So we can try to connect this when thinking about this link. We can connect it to ordoliberal school of thought. So that's I would say, first, if you would like to discuss this link, that's the first area. The second one, and these are interesting developments concerning digital markets in the EU. Maybe some of you heard about the enforcement against Google. There are a couple of cases that were brought by the European Commission. One of these cases is a Google Android case, were basically at the moment when, you know, kind of internet, I would say, was moving from laptops to smartphones. Google wanted to make sure that Google search will remain a key search engine also on our mobile phones. This is at least the theory that was put forward by the commission, and that was in principle confirmed by the general court. And what the Google did, Google expected the manufacturers of smartphones to pre-install Google Search and Google Chrome on Android devices. So we know that Android is a Google product. In order to get a license for Android, producers of smartphones needed to pre-install Google Search. And this might be seen as a classic competition law case, in a sense that we are having a dominant firm that is using its market power to kind of maintain it. And you could argue that the way they do it is not competition on the merits, but it has but it brings risk to competition on the market. But if we look at the judgment of the EU General Court, this is a first instance court in Luxembourg. What the court is saying in paragraph 1028, so quite a long judgment, when it is describing all this practice by Google, it is basically saying that consumers were harmed by Google practice in being deprived of possibility of having more than one source for obtaining information on the internet, that such a practice could restrict the development of search engines which would offer, better services, for example, those that would better protect the privacy of consumers. But then the court is really saying that it's not only about consumers, it's not about the markets, there is something else that is maybe more fundamental. So this is towards the end of this paragraph, where the court is saying that such consumers' interests were not only consistent with competition on the merits, in that they encourage innovation for the benefit of consumers, but were also necessary in order to ensure plurality in a democratic society. So in this context, you could see, enforcement against Google as the idea that if we are stick just to one search engine, as a democratic society, we are deprived of diverse source of information. And this is, by the way, in line with the case law of the European Court of Human Rights I discussed yesterday. So this is more specific for digital market, but this access to information, ensuring plurality, this is where you could see that. This I'm leaving, but potentially you could discuss that enforcement of competition law is in line with socioeconomic rights and environmental values that are mentioned in many modern national constitutions. There is also a procedural link between competition law and democracy, in a sense that we want to have competition law being based on the rule of law. We want to have competition authorities to stay within the limits of the law. We need due process. We need also right of defense of firms in order to make sure that competition authorities do not abuse their powers. So if we think about rule of law as an important value of liberal democracy, we can argue that it is also part of the competition law. So there is like procedural link, which is very important in the context of democratic backsliding, because at least for me, the consequence of the idea that competition law needs to be based on rule of law is the requirement that competition authorities needs to be independent. So when you think about these links, I guess that when discussing the substantive link, you could think about the role of competition law vis-a-vis well-functioning media markets, maybe particularly when it comes to media plurality. You could see it from the perspective of plurality and access to diverse source of information. The question is, because the title for these two lectures that was proposed by the title that was proposed by Stigler Center was "Can Antitrust Save Democracy?" So it's a very big question, and if we think about the processes that undermine democracy, the question might be that needs to be addressed whether, if we think that there is such a potential role, the question is whether it can really work in the context of countries that are subject to democratic backsliding. And in my work, I did a research concerning how competition agencies, how competition law enforcement works in the countries that are subject to democratic backsliding. And my findings are, maybe not that surprising, that competition agencies and also the courts that review their decision are in a way they are part of the story. Okay, so it's not that competition law and competition law enforcement is sort of an island that is not affected by the broader changes that are taking place in countries going through the process of democratic backsliding. And what I identified as a challenge, and very often I hear a question, okay, but this processes also exist elsewhere. But for me, what's quite important is that we are observing a sort of accumulation of these processes that may really affect the way in which competition law enforcement operates. So when it comes to independence of competition agencies, I identified that appointment process of leaders of the agencies is politically driven. There is a limited autonomy of decision makers within the agency structure, and there is also a negative perception of agency independence by the stakeholders and the broader societies. I also identified that if you think about really operating capabilities and resources, it's not easy for a competition authority to function within this, I would say, new environment. And you very often see staff leaving the agency. You see that financial resources that competition agencies have are not sufficient. There are problems concerning judicial review. So, for example, the reform of judiciary in Poland that were seen by many, including EU courts, as undermining the idea of effective judicial protection, independent judiciary, was very relevant for competition. So the changes in the Supreme Court really affected the way in which competition law cases are reviewed. And there is also a question how competition law operates within this illiberal environment is the question about enforcement. And what I see as a problem is the enforcement that can be referred to as selective enforcement and selective non-enforcement. So you may have some cases being opened that are politically motivated. You don't necessarily see other big cases than those where there is, a political expectation that the agency will open the proceedings. And on the other hand, you see a self-restraint. So you don't see much of enforcement with respect to these firms that have a big market power and that are connected to ruling politicians. The problem is also that sometimes the powers, the competencies of competition agencies are limited, and for example, in the case of Hungary, that was a case of enforcement when it comes to agriculture market. So if you think about populism defined as from the perspective of the actual rule of populist governments that undermine liberal democracy, this is the process that affects markets and democracy, something I discussed yesterday. But this is also relevant for the competition law, and it may undermine the role of competition law in preserving competitive markets, but it may also undermine the role of competition law with respect to its pro-democratic role. And let me give you two examples from concerning media markets. One is a case concerning a merger between Agora and Eurozet in Poland, where you have a situation that Agora is number 5th on the market. It's a media group that owns, among others, radios. It also owns a newspaper. It's basically a media group that is very critical towards the law and justice government. And this player wants to buy a Radio Z, the second biggest private radio at the Polish market. So, and we have a leader. This is another private radio that has a position that is close to 40%, that could be seen almost as a dominant position. And we are having a merger in which Agora is buying Radio Z. So after the merger, we will have the market share more or less. This is just an illustration. We'll look around that we will have this leader with the same market share, and we have a second one will be stronger. It will have a 30%. And this transaction is notified to Polish Competition Authority, and Polish Competition Authority goes as far to prohibit the transaction. It prohibits the takeover of Radio Z by Agora, arguing that basically we will have a market in which it will be sort of a duopoly where we will have two strong market players, and this is bad for the market. The question is, if you read this decision, whether it is, whether the reasoning is well written, whether you have really the arguments provided there, and whether you really have the evidence that this transaction can bring risks to competition on the market. And here is also the question when independence of competition authorities come into play, because basically in this case we were discussing a situation in which a media group that was critical to government wanted to take over the radio. So, and if you look from kind of rule of law perspective, from the perspective of independence of competition authorities, if you analyze the decision, you might have doubts whether they really provided the evidence, particularly when it comes to the risks that in this post-merger scenario, these two market players will kind of, that there is a risk of collusion between them. So it's an illustration of the risk. Okay, so in the sense that you could think that here the competition law will play its classic role, whereas I'm not maybe saying that far that this really happened, but you may have doubts whether that was a decision that was based on merits, and prohibition is really that, let's say, the last resort that competition authorities can use. By the way, this decision was overturned by the court at the appeal level. So finally, at the moment, basically this transaction went through. Another question is really, when you think about media markets and media plurality, the question is whether, if you think about this pro-democratic role of competition law, whether we can say that in the context of this broader processes linked to democratic backsliding, whether competition law can indeed play such a role. And there was another transaction happening more or less at the same time, where the oil refiner, Polish national champion, state-controlled enterprise, decided for relatively strange, unknown reasons to enter media market, local media markets, and they bought Polska Press, who owned local newspapers, local websites, portals all over the Poland. And in this case, the competition authority quickly cleared the transaction. So you could potentially think about the risks that are posed by to media by a concentration that involves the most powerful Polish firm that is very closely linked to the government. Basically, we had a CEO of this firm saying that he considers himself to be part of the law and justice, to really scrutinize this transaction. And of course, here the question is whether you could ban this transaction just on the basis of the idea that it brings risk to the media plurality. But the question is whether really there was a sufficient analysis under pure competition law, because in this case you could argue that there were risks of foreclosure in media distribution, and also the question, and the question that was really addressed, how the whole of how the takeover will more broadly affect media market in Poland. And by the way, what happened after the transaction was cleared, after the takeover was cleared? Very quickly, the heads of these local newspapers were changed, and the editorial line in this newspaper changed. So you could see that after the takeover by the state-owned enterprise, the content in these newspapers became pro-governmental. So the question is, whether this is something that could have been addressed under competition law as it stands in Poland. I think this is difficult, but this opens a discussion about maybe the need for some additional tools that would under which you could review the negative effects on certain transactions on media plurality. So democracy brings risk for competition law with respect to its pro-democratic role, and institutional and procedural safeguards are crucial. So if you would like to think about potential improvements, how the system could be changed, of course, we could have a discussion whether competition law could be seen to directly protect media plurality. I think this is a jurisdiction-specific question. It's at the very end the choice to be made by a legislator in a given country. I can think of different models, but what these cases from Poland, what they teach us is really that that these institutional solutions are important if we want to consider having competition law playing this pro-democratic function. So it's important that the competition authorities are independent, not just on paper, but also in practice, that they have sufficient resources, that we have a proper due process, safeguards and obligation to state reasons by the agencies in a possibly persuasive way. If we think about this kind of self-restraint scenario of not opening certain cases, it would be good to think how we can better know what kind of cases are not opened by the agency. It is also important that we have judicial review in place. So it's so we need to think about, on one hand, making competition law system and competition authorities more resilient vis-a-vis democratic backsliding. So imagine you live in a country in which political forces that are anti-democratic could win. I think it's good. It's a moment to think where we are with our institutions and maybe how we could make them stronger, and lessons from Poland and Hungary maybe can help. But the other thing is really we need to also discuss enhanced accountability and transparency. So in this Polish cases, it was clear, for example, that competition authority was not interested at all in hearing from journalist association. It was not, ombudsman was declined to join the proceeding. So there was this kind of approach of deciding the case behind the closed door with a limited involvement from the party. So this is about competition law, and the question is, I already hinted this about regulatory answer. So if we have competition law, we can discuss this pro-democratic role of competition law. We know that there are limitations when it comes to enforcement of competition law in the countries that are subject to democratic backsliding. So is there alternative? And on the basis of, I think learning to a big extent from the challenges we discussed yesterday, that concerning media markets. So there was this long list of challenges. European Commission decided to propose a regulation to address these many problems that concern media markets. And this is a very new piece of legislation. You see, it's from 11 April, recently adopted. It is called European Media Freedom Act. And its principal goal can be seen to protect media pluralism and editorial independence in the EU. It has a very broad scope. So it covers media service providers. So we are talking about TV, radio, broadcast, on-demand audiovisual media services, audio podcasts, press publications. It also includes, as under the definition of media service provider, a video sharing platform, as long as there is an editorial control over the services that this platform provides. And it covers different areas, but it is based on the idea that is in line with the European EU Charter on Fundamental Rights and European Convention of Human Rights about the right of recipients of media services. So in Article 3, the regulation states that member states shall respect the right of recipients of media services to have access to a plurality of editorially independent media content, and ensure that the framework conditions are in place. So it's it is also quite in line with this idea of positive obligation I discussed. So it's not just about non-interference. It's also about certain legal structure that is there in the country to make sure that this right really exists. And if you look at the preamble to this directive, it is underlined that such a framework is necessary to empower citizens to make informed choices, including about the state of their democracies. And the elements, the list is long. It includes editorial independence. So member states should not interfere within editorial freedom and independence of media service providers. At the same time, there are rules about confidentiality of journalistic sources. There are provisions concerning public media. I discussed public media yesterday. So states can have public media, and they are important, but they shouldn't be basically captured. So it is important that this public media are independent from the government. Another element, and it is also linked to the challenges I discussed yesterday, is transparency of media ownership. The idea being that we will have a disclosure who really owns a media, and there will be even a public databases in this respect in member states. There are provisions concerning the safeguards against the unwarranted removal, but very large online platforms of media content. So if something, the idea is that if something comes from media service provider, it should be marked as being, a trusted source, and very large online platforms should not have, a power to remove such a content from the platform if the conditions which are there in the regulations are met. Other things is a right of customization of the media offer on devices. So we should be able as consumers to kind of, be able to decide what kind of content, media content we are receiving. There are provisions concerning transparent audience measurement methodology, and also, and this is very important from the point of view of this economic developments. I discussed the question is about allocation of state advertising. So there are provisions concerning the need of transparency and reporting with respect to allocation of state advertising. And what is key from the point of view when thinking about the link, between the approaches under competition law and regulation is the question about media pluralism. And at the moment there are different approaches existing in member states, but the regulation proposes so-called media pluralism test in Article 22. So the idea being that member states will be obliged to provide an assessment of the impact of key media market concentration on media pluralism and editorial independence. So if you think about this case where state-owned enterprise is taking over a local media, this should be the transaction that is subject to this media pluralism test. I am a little bit disappointed with what we really find in law, because it seems to me quite general. But what the regulation calls for is that we should have this media plurality test in place, that the rules that are applicable need to be transparent, objective, proportionate, and non-discriminatory, and should be subject to pre-notification. So the idea being that there is a need to a pro-notification of that transaction, and then you have the procedures that are transparent, objective, and proportionate. And this is also, if you think about the merger control rules, the idea is that we are talking about the rules that are distinct from competition law assessment. So there is so in practice we will have in member states on one hand the assessment with respect to negative effect on competition, this negative effect on competition, but on the other hand we will have a test that will be just focused on media plurality. Whether they list the criteria how to assess it. The whole idea is behind this about this external and internal media pluralism. So you don't have a very precise test. So we will see what the member states will do. For me, what you find in the preamble maybe is the most interesting. What they say that the criterion should be a reduction of competing views within the market as a result of the market concentration. So you can ask yourself a question how this test will be implemented, and I think it has a potential to improve or preserve media plurality in member states. However, a key thing is whether the authorities that will be responsible for this procedure under media plurality test, whether they will be independent. So I don't think, for example, that in the context of Hungary, one can expect that this introduction of this media plurality test will change the media landscape. So I would see it more as a precautionary tool for the future. And I'm leaving this. There are other rules, as I mentioned, concerning state advertisement in media sector. But yesterday we discussed these cases where you could see how state advertisement, particularly coming from SOEs, that it can be a very powerful tool to design a media landscape in a certain way. And there are other pieces of legislation in the EU, like a regulation on the transparency and targeting of political advertising. So to sum up, I discussed the role of competition law. I think there are limits to national competition law. Maybe we could discuss. I'm happy to take questions. Maybe the question could be, so what the EU could do with its competition law. So if you have problems with enforcement of competition law at the national level in the EU, we also have the European Commission. So maybe the European Commission should be more active. The question is whether it is. I have doubts. But then we may think about regulatory answer. And here I think the EU is again taking the approach that is the one that I'm not aware of, for example, in the US. So we have a regulation that is subject to cover and address different challenges. And I believe that there is it has a potential of playing a complementary role to enforcement of competition law in media markets. Thank you very much. And I am happy to take your questions.
I have two questions about the competition law element that you talked about. The first one is, are there any examples of countries that, because they've seen the process of democratic backsliding in other countries, have adopted some of those bullet points you had about making their competition law authorities more independent to safeguard against something like that happening? And the second one is, in places like Poland or Hungary, where some of the process might already have taken place, so where the competition law authority might have been captured to some extent. is it possible for the EU to introduce legislation, regulation that sets out some basic rules about what an anti-competition or a competition authority needs to look like in an EU member state? Or is that outside the limit of EU competency?
Okay, so I think these two questions are connected. It's a very interesting another piece of legislation from the EU. It's called so-called ECN Plus directive. So the directive was adopted a couple of years ago, and it is right now in force and should be transposed in the legal system of member states. And the idea is to make competition authorities, national competition authorities, to be more effective enforcers. So there is this law, and it's I think it's article, yeah, it's right at the beginning. I think it's article 4 or 5. It talks about independence of competition authorities. So and I heard that there was a certain level of initiative actually coming from national competition authorities. That it could have been that they were facing the challenges concerning their independence vis-a-vis their national governments. So they kind of work, because they also work together as a network. It could have been that they were decided to go, let's say, through EU law, and then we have the directive and it needs to be transposed. So at the very end, it will the idea being that it will strengthen the independence. Before this directive, we didn't have in the EU secondary law the requirement of independence of national competition authorities. Right now we have it. The question is whether it will change things in practice. I think this is country specific. The directive, I would say it was not designed for countries that are subject to democratic backsliding. So if you have a democratic country, then I guess such requirements of independence might help. But for example, they did not go that far to say that when it comes to appointment process, the directive requires the appointment process to be transparent. But still, you cannot exclude under what you'll find there in the EU law that you will have a political, so to say, appointment. That we will have a former member of the party being appointed as the head of the competition authority. This is linked to different approaches existing in member states, and also the idea being how far we should go, in kind of detaching competition authorities from the government and views on that. And also, if you think about democracy, how far we want to have competition authorities being when thinking about accountability, for example, whether we want to have technocrats. My idea is that we will have these improvements. So on one hand, we will have independence, but the structure would be that the competition authorities are more open for the diverse views that exist. So and when it comes to the initiative kind of coming from member states, improvements like in the EU, it is as I said, this is the ECN Plus directive would be my answer.
Okay, I wanted to know, take the discussion outside competition, but stick to media and democratic backsliding. What's the limit of the law of defamation and libel in the EU? Are defamation cases on the journalist, or have they to be faced by the media house? What are the limits there, and is that used as an instrument to pressure the media? The second question is, there is more criticism nowadays on social media. So what has been the record of countries like Poland and Hungary on takedown requests to Twitter? We understand that, I mean, the last published record from Twitter is that the maximum requests came from Japan, Russia, Korea, India, and Turkey. European countries didn't figure in the top 5, but would you have an idea?
Okay, so when it comes to first question, what I didn't mention that what the directive, what this regulation introduces is so-called protection against so-called SLAPs, so strategic lawsuits against public participation. They also exist in the US. I think in California there is a prohibition of SLAPs. So certain level of protection against the cases, which basically the idea would be to chill the public debate. Okay, so you have certain rules there, but still, you know, it's not that. I think it's hard. This is a case specific. So in some cases, you might have a situation there was a defamation. So I don't think that EU can impose rules, you know, concerning this area of law. However, at least when it comes to certain kind of suits can be considered as the SLAPs, and here the EU law can offer some you know source can be considered as a point of reference maybe for countries who like India, I understand that may face problem in this respect. About Twitter, I didn't see, you know, much of action on let's say particularly in Poland or in Hungary, like politicians use Twitter. The problem is in Poland that there were some cases in which you could say that you have, you know, artificial accounts there that may be controlled by Russia. So this is a big issue before the election. So this is not so much there. I'm not covering this, but there is another act, Digital Service Act in the EU that is directly about large online platforms and the situation like Twitter. And you may be interested in the case where recently opened under the Digital Service Act where the European Commission instituted proceedings against Twitter. Basically, it is about the illegal content in the context of Hamas terrorist attack against Israel. Because there are certain rules that, you know, that they need to, the question is how, you know, moderation should look like, but apparently in this case, it just started, the Commission claims that Twitter did not do enough, and it didn't have, you know, a proper structure to eliminate a content that is, you know, you have terrorists posting horrific videos Twitter, and you can watch it. So there is another, you know, legislation called Digital Service Act that is more directly about Twitter.
I had 2 quick questions. Could you clarify who would be responsible for doing this media plurality test? Would that be for the national competition authorities when a merger is notified? Would it be at the European Commission level? And then second, what do you think that this EU Media Freedom Act has teeth? Could you contrast it to, for instance, the DMA and the DSA? Do you think that the Commission will really move quickly if it feels like member states are not complying with it?
So about 2 specific questions, I think, from expert in EU law, I guess. So thank you. So I would say that for the media pluralities test quickly, it's not set. It is left for member states to decide. So you can have a competition authority potentially being responsible for conducting this media plurality test. I would expect that in most of the cases you will have media supervision authorities that will be. So we will have 2 different institutions, one responsible for competition assessment, another for media plurality. The key thing is collaboration between them. I think then and there is a new case law concerning more data in the EU, but it seems necessary that if you have, kind of the competencies that can overlap one another, that these authorities interact. But I would expect that in many countries we'll have media supervision authorities. This is why I mentioned this question of independence, because as far as I know, and it's really my kind of observation from outside, but I think you might have doubts whether, for example, Hungarian media supervision authority is independent. So and right now it will be exercising this media plurality test. So if this was about making things better in Hungary, I'm not so sure that this is a very initial thought. About European Media Freedom Act and other like DMA and DSA. I think the approach here is quite different. So this is the regulation where a lot is in the hands of member states. So the role of the commission plays a central role when it comes to enforcement of Digital Market Act. It's very limited space for national competition authorities. With Digital Service Act, like this case against Twitter, again shows that here we have the commission acting as a primary enforcer. With respect to European Media Freedom Act, I mean, if they I would see it as a first step. So it was controversial in itself that the EU decided to regulate media markets in such a broad way at the very end. So I think we will have some time when the Commission will be really observing what changes it brought to the media markets, whether these rules were introduced, and maybe there will be some space of reconsideration whether this is enough. But potentially it opens a place then for infringement proceedings. It's like without this regulation, I think with this regulation, it's easier for me to imagine an infringement proceeding that would be somehow related to media markets that would go against a member state. Okay, so we are right on time. Thank you very much. Thank you for your questions. And if you have any questions to me, feel free to reach out. This is Maciej. Thank you very much.